people doing cutting edge research into the legacies of George Mason's ideas from the 18th century to today. And then we ask those researchers to make their findings easily digestible in 30 minutes or less. Today, we're joined by Dr. Andreas Meyris. Dr. Meyris earned a PhD in history from the George Washington University in 2023. He is currently an editor at the papers of George Washington and the Center for Digital Editing at the University of Virginia. He is working on a book-length project based on his dissertation, tentatively entitled Labor's Reconstruction, Social Democracy, and Progressivism in American Trade Unions, 1918 to 1925. And he's here today to talk about how American labor engaged with George Mason's notions of democratic liberty when they sought to enforce their own Bill of Rights in the wake of World War II. Thank you so much for joining us, Dr. Meyris.
Thank you for having me. It's a pleasure to be here, and I'm really looking forward to this talk. I have a PowerPoint that I will try to share at this point. Let's see here. Is that coming through?
Looks great to me.
Okay, perfect. Um, Great. So, participating in this virtual talk for Gunston Hall has provided me with a really unique opportunity to put my dissertation research in 20th century American labor history in conversation with some of the work I've been doing dealing with the founders and revolutionary America. I had a lot of different ideas run through my head, but a question that kept coming to my mind was, well, what was George Mason's impact on the American labor movement? And in one way, that's a remarkably easy question. Not a whole lot. He died in 1792. This is more than a decade before the Philadelphia journeyman cordwainers kind of led the first official strike in the United States of America. But of course, we're not purely talking about Mason's lifetime, but his ideas. And tracking his ideas is a much harder job to do. Um, so I was also fortunate enough this year to participate in National History Day, and its theme was rights and responsibilities. So because that's still somewhat fresh in my mind, I'm going to shamelessly crib off that phrase and say that certainly Mason believed that both needed to be cornerstones of any constitutional democracy. But again, I'll emphasize the central question: how do the legal rights Mason thought of as crucial to a democracy apply to rights in the workplace? So I'll take a moment to acknowledge the big differences in working life between the America of the 18th century and the America we know today. Back then, the United States was overwhelmingly rural and would remain majority so until 1920. Professional craft workers usually had near monopolies in their communities. While there is some debate over exactly when industrialization began, suffice it to say that there weren't many huge factories churning out goods. Textile mills opened in New England starting around 1815, and they were considered such a novelty at that time that Andrew Jackson and Charles Dickens both visited. Beyond chattel slavery and varying forms of unfree labor that were hallmarks of the era, there were always teams of barely employed, quote, unskilled workers in cities, but at this point in time, they existed on the peripheries of government action, aside, of course, from criminal prosecution. That changed with industrialization. Increasingly, the majority of workers toiled for wages and salaries that were dependent on boardroom negotiations they didn't take part in. This is when we start seeing the rise of unions as we know them today. By the late 19th century, the United States had fairly well-defined stratas of class. There was a mass industrial workforce that increasingly turned not only to unions for relief, but to politics to bring about industrial reform. Now, I'll try to connect the 20th century American labor movement with the founding principles of the 18th century, and I'll highlight here a couple of well-known clauses from the Virginia Declaration of Rights, which, as we know, Mason largely drafted because I think they can serve as some useful guideposts. And this will be sections 1 and 3. They're dealing with kind of the right of assembly. I'll read from them briefly here. That all men are by nature equally free and independent and have certain inherent rights of which, when they enter into a state of society, they cannot by any compact deprive or divest their posterity, namely the enjoyment of life and liberty, with the means of acquiring and possessing property and pursuing and obtaining happiness and safety, and that government is or ought to be instituted for the common benefit, protection, and security of the people, nation, or community, of all the various modes and forms of government that is best, which is capable of producing the greatest degree of happiness and safety, and is most effectually secured against the danger of maladministration, and that when any government shall be found inadequate or contrary to these purposes, a majority of the community has an indubitable, inalienable, and indefeasible right to reform, alter, or abolish it in such a manner as shall be judged most conducive to the public will. There's a lot of long words in that one, so try not to get tripped up. Um, let's see. So in 1919, representatives of the American Federation of Labor and the Railroad Brotherhoods, a collection of unions representing different sets of railway workers, held a conference and drafted a document many union representatives called Labor's Bill of Rights. So Virginia accepted those declarations in 1776, and now we're 145 years in the future. This is after, of course, the Virginia Declarations became sort of the basis of the Bill of Rights. Okay. A bold declaration of labor's place in American history, the drafters claim to speak in the name of millions, those who make and use tools, those who furnish the human power necessary for commerce and industry. Our welfare and our interests are inseparably bound up with the well-being of the nation. They likewise warn that, quote, autocratic political and corporate industrial and financial influences had infringed upon and limited the fundamental rights of wage earners guaranteed by the Constitution of the United States, end quote. Namely, by denying them the exercise of their freedom of action, freedom of association, and freedom of expression. Before getting into more details and the more prescriptive nature of Labor's Bill of Rights, a little background on the moment in which it was drafted. Organized labor's power had grown substantially during the First World War. After Congress approved Wilson's declaration of war in April 1917, the U.S. economy jumped into overdrive. The military needed goods, and it needed them fast. To do that, industrial leaders needed workers, and they needed them to cooperate. Trade unions saw this as an opportunity to show their strength, demand recognition, and bargain for higher wages and shorter workdays. For its part, the Wilson administration worked hard to avoid any strikes, walkouts, or lockouts, all of which would interfere with plans for a speedy mobilization. For the duration of the conflict, the federal government empowered a National War Labor Board to arbitrate workplace disputes. While the board was only a regulatory agency and lacked real enforcement power, it was able to get workers and bosses to accept voluntary mediation by dangling carrots like additional government contracts and other lucrative trade deals. It also threatened potential sticks like the loss of these contracts or enhanced government oversight. The result was a stratospheric rise in union membership and significant improvements in wages, shop floor safety, and time away from work. Never before had the federal government given trade unions such broad legitimacy. The growth of trade unions, coupled with Wilson's soaring rhetoric about fighting in the war for freedom, enhanced demands for industrial democracy. This phrase is largely self-explanatory. Workers wanted the democracy Wilson promised the world over at their place of employment. Quote, the great victories for human freedom must not have been won in vain. They must serve as the instruments and the inspiration for a greater and nobler freedom for all mankind. This comes from Labor's Bill of Rights. It encompassed something slightly more than better hours and wages, though it certainly included those things. Sidney Hillman, president of the Amalgamated Clothing Workers and a Jewish immigrant from Eastern Europe, explained, What labor is demanding over the world today is not a few material things like more dollars and fewer hours of work, but a right to a voice in the conduct of industry. Now, Hillman didn't take part in drafting the Labor Bill of Rights, but a very similar sentiment appeared in the section that read, wage earners aspire to be something more than numbers on the books of an industrial plant, something more than attendants of a machine, something more than cogs in an industrial system dominated by machinery, owned and operated for profit alone. The workers insist on being masters of themselves. So workers wanted a paradigm shift, a right to contribute to leadership functions where they earned their livings. Trade union leaders also sincerely hoped the gains they had made during the war would continue in peacetime, but they knew economic realities made such an occurrence unlikely. The flip side to red-hot demand for war goods meant a dwindling supply of consumer goods for civilians. Food, clothing, and especially fuel skyrocketed in price. Home construction could nowhere near keep up with the thousands of families heading into major cities looking for industrial work. Inflation became a serious problem, and business leaders and Wilson opponents increasingly blamed unions and government bloat for it. Once the military began demobilizing and the federal government started scaling back from a wartime state, trade unionists alongside liberal and progressive politicians pleaded with the Wilson administration to extend agencies that regulated employee-employer relations. They hoped to forestall a rapid decline in earnings and hours. But Wilson, before a debilitating stroke sidelined him almost entirely, turned his attention to the League of Nations. Industrialists felt emboldened to reverse course on union recognition and protect their post-war bottom lines by reducing labor costs. This sentiment contributed to what became the first Red Scare, a largely nativist hysteria against largely foreign-born suspected revolutionaries. The federal government either sat aside or actively assisted in breaking strikes, and even deported some labor leaders it believed harbored Bolshevik beliefs. So this was the context behind labor's Bill of Rights, a summit of unions making their wishes known as the business and political environment around them began to deteriorate. Some of the demands in that document organized labor had made decades prior. The 8-hour workday, for instance, a rallying cry as early as the 1880s. The 48-hour work week they also asked for. Note here that they were asking for a single day off, not the whole weekend, and a prohibition on child labor, with continuing education for young workers not yet through high school. States and municipalities, this is just a side note, had begun to restrict child labor by this time, but there wouldn't be any kind of national ban on it for another 20 years. Uh, but other labor demands in the document reflected the tumultuous changes of the war years. The drafters here, for instance, insisted men and women receive equal pay for equal work. Now, this is a bit fraught, and equal work is doing a lot of heavy lifting here. Not to mention that several unions authorized strikes against employers who refused to lay off women employees once men returned from the front. But it was an acknowledgement that women were entering the industrial workforce in greater numbers and that that was unlikely to change. Better to protect those workers and bring them into the union rather than alienate them and weaken any closed shops. There were also calls for the government to tackle inflation, which labor leaders blamed on, quote, profiteering by those who manufacture, sell and market goods, and to burdens levied by middlemen and speculators. The solutions they offered, albeit vague, mentioned the, quote, prevention of hoarding and unfair price fixing, the establishment of cooperatives, making accessible all income tax returns and dividend declarations. There were, interestingly, also hints at a style of economics popularized in the next decade and Great Depression. They theorized that the organization of industry for service and not for profit alone. Industry needed to be adjusted, reconstructed was the term they often used, to prioritize service and consumption, an economy that didn't measure progress by the output of goods, but how much consumers were spending. But the largest portion of labor's Bill of Rights dealt with what the unions considered the most pressing matter at the time, federal court injunctions. An injunction is an umbrella term for a mandatory court order directing parties involved in a legal dispute to do something or to not do something. The 1914 Clayton Act had partially restricted injunctive relief to break up peaceful labor disputes, but that law also contained a crucial carve-out, allowing injunctions if, quote, necessary to prevent the irreparable injury to property or to a property right. This made it remarkably easy for any employer to claim property damage in the form of lost profits and get legal authority to break strikes. So after the war years, when strikes became more numerous and desperate, union leaders accused courts of usurping legislative authority and the rule of law. As Labor's Bill of Rights stated, the injunction as now used is a revolutionary measure which substitutes government by judicial discretion or bias for government by law. It substitutes a trial of one by one man, a judge, in his direction for a trial by jury. This abuse of the injunctive process undermines and destroys the very foundation of free institutions. And this is where we get another connection to Madison, albeit via a false soul attribution to Jefferson. Sorry in advance, Gunston Hall team. They write, quote, "The warning given by Jefferson that the danger to the people of this republic lies in the usurpation by our judiciary of constitutional authority has been fully demonstrated. A judiciary unresponsive to the needs of the time, arrogating itself to itself powers which neither the Constitution nor the purposes of our laws have conferred upon them." Compare this to Madison in his objection to this constitution of government. The judiciary of the United States is so constructed and extended as to absorb and destroy the judiciaries of several states, thereby rendering the law as tedious, intricate, and expensive, and justice as unattainable by a great part of the community as in England, and enabling the rich to oppress and ruin the poor. In the years to come, labor did have a series of stinging losses in federal court. By 1923, the Supreme Court upheld the post-1914 injunction process in labor disputes, outlawed organized boycotts, and allowed companies to seek damages from unions during work stoppages. And in Adkins versus Children's Hospital, the courts overturned federal minimum wage protections for women and children. More and more, trade unionists and their allies believed that the courts served as an impenetrable bulwarks of elite power, invalidating popular laws and preventing wage earners from having a say in their working conditions. If the people are to rule and America is to work out her economic political destinies peacefully, further encroachments of the Supreme Court must cease, wrote a Federation of Teachers founder Abraham Lefkowitz. Louis Boudens, then a Progressive magazine editor, claimed, quote, "In Lincoln's day, the Supreme Court was the citadel of slavery. Today it is the stronghold of monopoly." Labor's Bill of Rights called for electing all judges to federal courts to 6-year terms and included a vague idea of a congressional check to judicial review, a power they correctly pointed out is not specifically written in the Constitution. And I'm happy to talk more about this if there's any interest once we get to the end. Now, the New Deal era National Labor Relations Act softened labor's attitudes toward the court system by setting up a parallel arbitration process through the National Labor Relations Board and largely ended these kind of demands from labor by the 1940s. But I should note, even today, the issue of judicial oversight is far from settled in labor's eyes. So to wrap up, Labor's Bill of Rights, unions insisted they had a right to demand a, quote, progressively advancing standard of life, not wages fixed solely on the basis of family budgets and bread bills. And this is what I'd like to conclude on, because I think it is a useful callback to Mason and Gunston Hall. Americans have always interacted with the founders and their writings. Mason might not have mentioned work and collective bargaining explicitly in his drafts and treatises, but that didn't stop many people centuries in the future from applying his words to their conditions anyways. I hope this presentation serves as just another reminder of how Americans, past, present, and future, have, can, and will interact with history. Thank you.
Thank you so much for joining us, Dr. Meyris. I really enjoyed hearing about your research. Some things that struck me is so much of the Virginia Declaration of Rights and then the Bill of Rights ultimately are about the right to property. And
Hmm.
I spend most of my time in the 18th century. So when you were talking about this switch to urbanization and industrialization, it started to make me realize what a change that was in how people thought about their property and a switch from property being in real estate, whether
Hmm.
that was, land, physical movable property before the Civil War, human beings, to a mixture of like property in terms of, owning a factory, but also like wage. And
Yeah.
I'm curious if you have any additional thoughts about that transition and how the people involved sort of thought about their property or the idea of property rights.
I mean, that's really interesting. In the whole injunctive process, the idea that damage to property could come in the form of lost profit was really interesting because it goes to show how much interstate commerce had kind of unified the economies of the various states. That's a huge difference from the world in which Mason was writing from and kind of post-industrial America, and that the courts were largely receptive to this more expansive notion of what property is. So yeah, that's a massive change, and I agree. It's really interesting to think about in terms of the broad course of American history. So yeah, I hope that answers your question. Yeah, property as income and specifically industrial income is something that yeah, I'd like to look into further.
Yeah. Now I want to too. So thank you.
You're welcome.
So we are getting some questions from
Mhm.
people live, and if you are watching this live, please do submit your questions for Dr. Myris. I have one that I hope will be fun. What was your favorite primary source?
So we were talking a little bit before this session started about the one image I included in my PowerPoint that let's see if I can actually go back to that. Just because I'd love to highlight it in case anyone missed it. This is from a magazine called Labor Age, and it's this one on the top left, which is from a magazine talking about theater workers unionizing in the early 1920s, and just things like this. Somebody asked about favorite primary sources too. I believe you just find so many things that you never really knew about. And even if they don't make it into your work, it kind of changes how you see the era. And yeah, this the all equity chorus from the Greenwich Village Follies is just a wonderful little tidbit of the era in the 1920s, which most people kind of assume is the flapper era, and they think of chorus lines and the idea that this intersected with kind of the labor rights I was looking at was just a fun little tidbit to see.
Yeah, absolutely. And if I understand correctly from looking at this, one of the things they're highlighting also is that this is like crossing language and ethnic boundaries and building
Right.
these coalitions among diverse chorus girls.
Yeah. New York City then as it is today is a multilingual city, which has always made kind of labor organizing in that area a little bit more difficult. But this idea that, yeah, there was crossing language and ethnic barriers, and that they were doing that through unionization, which is an argument in the book Making a New Deal by Cohen, if anyone wants to kind of look more into how that process during the New Deal. But yeah, it's fascinating. Yeah, I think they say, what did they say? English, Hebrew, Polish, and Bohemian are the languages here. So yeah, there is a pluralistic vision that kind of emerges in the 1920s in a real way, and not just kind of a the Americanization that we also see during that era and the kind of retrenchment to nativism.
And it's also, they're speaking a common language of rights and labor.
Yes, that's right. To highlight it back to the theme, good connection, Kate. Yeah,
Yeah, that's why they put me on camera.
yeah.
Um, so I think we have time for one more question,
Okay.
and we've got one more from the audience, which is, was there anything in your conclusions or something that you identified that was most surprising to you, when you began this research and started thinking about these connections?
So I I'll say that I didn't fully realize at this point in time just how much of a problem labor had with the court system. Like I think that was, I vaguely understood it, but this idea that they should put a check on the power of judicial review, the idea that the Supreme Court shouldn't be allowed to invalidate congressionally passed and presidential approved legislation is not really something I'd come across often before. And yeah, like I said, there were numerous theories about how to go about this, and they never really settled on one way. But the most common idea was, and I think this is fairly similar to how it works in the British Commonwealth, Canada in particular. If the Supreme Court has to review a law quickly after it's passed, and if they disapprove of it, they send it back to Congress, and Congress can either vote to override that judicial review process or change the law, part of the law that is considered unconstitutional and pass it again. So it's just kind of a different process of the federal court system and legislation than I had really researched before, and I found that really interesting. And something that I definitely want to highlight in my book length project a little bit more.
Yeah, that is fascinating. And I think if my memory serves, George Mason actually raised wanting perhaps a similar system at the Constitutional Convention, um, particularly also in place of leg or executive veto power. He was like, what if judges got to get together and suggest revisions and send things back to the legislature, that the executive wasn't comfortable with? So there is that kind of interesting, transatlantic
Yeah.
dimension throughout history showing up again.
Absolutely. And yeah, I that's I when I was reading through some of Mason's work the last few weeks, I noticed that like he had a lot of concerns about the judiciary in particular, probably more so than even the presidency, which was another branch of office that he was concerned about. So yeah, I think labor absolutely shared those concerns 175 years later. Yeah.
Yeah. Oh, fascinating. And I really enjoy seeing all of these connections shouting out across time to one another. So thank you so much for joining us today, Dr. Meyris, and to all of our audience members, thank you so much for being a part of our first ever installment of History Bites. We will see you back here with another feast for your brain on the third Wednesday of next month. That'll be May 21st, when we will be joined by Dr. Alex Finn McCartney, who will be discussing the history of student protest and campus activism. So thank you all, and I look forward to seeing you again. Stay hungry. Okay,
No longer live?
apparently not.